Yeah.
I heard you okay.
I'll be vice chair.
Procedures. You don't want to get them.
You're one of the 3-year term.
Yeah.
And I'm one of the 2-year.
You'll come back on after this year.
Because nobody else.
All right, so I think we're live streaming now, so we'll move forward to the second item on the agenda. So there's electing a chair and a vice chair. As you know, Katarina's not available. She wasn't able to take her oath yet, so she wouldn't be able to vote. So we have two choices here. We can move forward with just electing a chair and our vice chair, or we can move forward today with just electing a chair for the day. And then during the next meeting, we can proceed with electing a chair and vice chair for the board for ongoing. So
Have you asked if she wants?
I have not asked. I just let her know. We let her know via email earlier when we sent her a link to the stream that that would be the issue with her not taking her oath today.
What's involved with being chair or
Yeah.
vice chair?
What are the responsibilities?
I think mainly is that you would sort of be the chief of presiding over the meeting. So you would basically be calling the agenda. Another thing would be is that since some of the actions that you'll be taking is a quasi judicial hearing, the chair usually acts as a judge. Sometimes if there are objections or pretty much running the meeting and things like that. So the chair's pretty much.
It's 100% in this room. Outside, there's anything the chair has to do.
No, not really, because really what you all are doing is hearing appeals from citizens and you're acting in a quasi judicial manner, which really means that you kind of have to stay neutral and you basically have to base your decisions on the information that's presented to you at the hearing. And you can't really be relying on outside information or making outside comments. So no, really the chair would basically be the person who would be presiding over these meetings. It's not like a public role, I would think.
And then the vice chair would just take over if the chair was not here.
Exactly.
So the chair needs to be good at pronouncing names, I bet.
Yeah, that a little bit, but once again, staff will be here to help you all with some of those things. So that I think is what the chair entails. And by the way, my name is Kurt Euler. Should I introduce myself? I'm one of the county attorneys. I'm actually the interim for a short while. So if you all have any questions or anything, please don't hesitate to reach out. And I just want to thank you because this is a really important board. So we really appreciate your service. Thank you.
Must be. We made it into the newspaper. We must be really important. Oh, what was the second? Oh, same article.
No, they added more information.
Oh, you see that.
All right, so
They're already ganging up on me.
okay.
They're already telling me that they're all voting for me.
Yeah, I'll make a formal motion that we appoint Randall our chair.
I second that motion.
Randall, do you accept?
I'll do it. How long? 1 year?
Yes. Well, once again, we will be presenting you in the probably at your next meeting, sort of some operating rules of procedure. So yeah, but usually when someone's a chair, the term is for 1 year. All right. I guess my next question for you all would be are there any more nominations? All right, then somebody needs to move to close the nominations.
So moved.
All right, and then since there are no more nominations, all those in favor of Mr. Brandt? Barnett, I'm sorry. My eyesight's not what it used to be. All right.
Mr. Grant's here. He can take.
He can too. All right, that. So I guess all those in favor of electing Mr. Barnett chairperson of the board, vote by saying aye.
Aye.
All right, congratulations.
I'm here to serve.
So I guess the next thing would be is to elect a vice chair if you all want to proceed with that.
Come on. I'll second it.
All right, who made the motion?
I motion we nominate Glenda.
Glenda? Okay,
I'll second it.
all right. And let me, is it Weinert?
Minor.
Weinert, okay. Do you accept the nomination? All right. Are there any other nominations?
She wants to do it.
No, then I guess I would close the nominations. I would make a motion to close the nominations.
All right, motion that we close the nomination.
All right. Is there a second?
Second.
All right. All those in favor?
Aye.
All right. And then you would need a motion to elect Ms. Weinert vice chair.
So moved.
Do we have a second?
Second.
All those in favor?
Aye.
Aye.
All right. Congratulations. All right. So now you all, and so we will get you some basic rules of procedure and things like that and help you.
Robert's rules, basically, Robert's rules.
No, we're not going to go near Robert's rules of procedure. That's a door you don't want to open. Eric, what is next on the agenda?
The next item is the meeting with the DOR charge.
All right. I guess we would like to introduce Mr. Stan Duncan and
Lindsay Smith.
Lindsay Smith. All right.
Can we just sit up
Oh,
there?
please do. Let's get you a mic.
You want to sit over here? No, you're over here.
First of all, congratulations.
Thank you.
If you'll permit us, we will sit during this presentation. So due to your unique situation and that you have a fully constituted Board of Equalization Review, this presentation is not the original. The original charge that we give most boards, even if they've been in existence as a board effectively for a couple of years, is much longer, usually 2.5 to 3 hours. And so this is going to be a very abbreviated form. So it didn't come up.
This one?
The second slide.
There you go.
Yeah, so this is the abbreviated version, and you can thank us later for that. It will put you to sleep, generally on the first one. But we want to go over the fact that, as your attorney, Kurt, mentioned, you're doing the work for the Board of Commissioners. You're actually sitting in their stead, because the statute originally, it was always the Board of County Commissioners who served in this capacity. We have now about 67 counties where they are a separate board, and that is the growing trend, is to have a separate board. That allows the Board of Commissioners, one, to sort of remove themselves from the political aspects of them sitting in front of taxpayers, property owners, to hear their complaints. And it also allows the Board of Commissioners the opportunity to appoint people who have a wide variety of expertise and experience from across the county to come in and listen to the variety of appeals. So it serves two functions. If you see me squinting a little bit to try to read this, it's because I've had eye surgery, and it's getting better, but I still can't fly and I still can't drive. And so I can't see as well as I would like to. So what we will try to go over today is the fact that you're operating in that capacity, okay? That you're not, you're taking some weight off the Board of County Commissioners. Statutes provide for it and have for many, many years, decades actually. It's been a slow process. So all the larger urban counties operate in this fashion. There's a few smaller counties where it's still the Board of County Commissioners. And we do have quite a few of small, very rural counties, some with populations of less than 7,000 people. So those tend to want to handle the things themselves as the Board of Commissioners might.
You're good.
So we
It
mentioned,
doesn't follow
Oh,
on
it
there.
follows.
She has to switch
Okay,
it in there because
okay.
it's not on my computer.
we'll let her catch up. So two important things. This is an old statute, but it's still in the law. You'll hear us refer to the Machinery Act. And it's called the Machinery Act simply because that set of statutes provides the machinery under which the property tax program can be administered in North Carolina. And this particular statute simply is a presumed notice to everyone in the state who either owns taxable property or may in the future acquire an ownership interest in taxable property, real or personal, that they have an obligation. Now, if you think about driver's license, every kid that's about 15 years old in the state of North Carolina and probably all across the country understands they need a driver's license. That's a presumed understanding. They have that. They do not have this presumed understanding amongst them. They do not talk about this part, but this is in the law. And some of the counties actually advertise this as part of their advertising notice for listing period in January. This is just a way to remind people they have an obligation, one, to list their property, to see that that property is accurately listed and described, and to notify the county of any changes that may occur. Now, that's not specified in that long sentence, but it is part of the presumptive notice. Next one. So there are two cases that I want to mention to you that come out. They go back some years. We have actually some cases that go back as far back as the 1800s, but these are more current. The people who come before you they have concerns. They have complaints about either how their property was listed, more likely how it was appraised and assessed and valued for tax purposes. And so the case of Bosley says that all tax, ad valorem tax, are presumed to be correct from the county. Once the county sends out a listing form, sends out a reappraisal notice, sends out a tax bill, the presumption is with the county. And overwhelmingly, in most instances, that's a very defendable position for the county to have. There are things that happen that you don't know about, that the county assessor's office does not know about. And if the property owner can bring that to you or to the tax office, there is relief available. You can make adjustments. So the second case is talking about how to go about those adjustments. And it's simply saying that, for the most part, if we boil it down, if the county has used an arbitrary method of reaching value or an illegal method of appraising and listing that property and reaching a value, then the taxpayer will prevail. They can show that the facts are this versus then the presumption by the county of Y. X over Y, X will prevail. And so that's simply the two of the probably the most guiding principles. And you will see that in orders. If the county takes the case to the Property Tax Commission, you will see that basis, those two items listed in the logic of the commission and their rulings, and generally repeated at the Court of Appeals and possibly even at the state Supreme Court. And I think this is where you take over.
I think so.
All right.
Okay, first we're going to get started with who can file an appeal. Anyone who owns or controls property within the county. Joint owners can file separate appeals. Their own property or the property of others if they're aggrieved. Normally, you're not going to get somebody who's aggrieved if someone else's property is valued higher than them, but they can do it usually if it's lower. That would normally be what you would think of when someone's aggrieved. A licensed attorney in the state of North Carolina, or business entity representatives. So principal officers, managers, member managers of an LLC, an authorized employee or owner. There are some other possible representatives. Sometimes family members will present on behalf of a taxpayer, or a tax rep. It is recommended that a power of attorney is on file to protect the county and the property owner. Consult county attorney if there are any questions about that, just to make sure everything's kosher. Yeah. Yeah. Okay. So first, you'll normally start out with informal appeals in a tax year. Those are assessor reviews. Basically, the property is requested to be reviewed by the assessor, by the taxpayer. The assessor has the ability to make adjustments if they deem fit. It's at their discretion. This would be prior to the board convening in the tax year. So it doesn't really apply to this one because everything for 2024 would have already gone through the informal review process. So for 2025, there will be an assessor review period. For what you're hearing today, that doesn't really make a difference because that would have already happened. And these were timely filed appeals while the board was convened for 2024. And the taxpayer, if they do not agree with the assessor's review, they can appeal to the Board of Equalization, which is basically just a formal appeal. Okay, and next, formal appeals. All these appeals should be heard by the Board of Equalization after they convene, usually March, April of the tax year. For this set of 2024 appeals, the assessor's authority to make changes is gone away because the board already convened for 2024. All decisions should be recorded in the minutes for the Board of Equalization, stating that the appeal is for 2024 and is effective for the tax year of 2024. Written notice has to be sent to the taxpayer about what the conclusion was. And then the taxpayer can appeal the board decision to the Property Tax Commission at the state level. And it would be effective as a 2024 appeal for the cases that you'll be hearing today. Okay, next we'll go to the appeals for the Property Tax Commission. Basically, the Property Tax Commission hears all the appeals from boards of equalization and review throughout the state. So if the taxpayer didn't agree with the decision, they have another step in the process. They can go to the state level, but they have to come to the Board of Equalization and review before they can get to that point.
Does that happen very often? Really? Okay.
Yeah. I wouldn't say it's like an abundance, but yeah, it does happen quite often.
If I may, it hasn't been a recent volume from Buncombe, but in our larger metropolitan counties, Mecklenburg, Wake, Guilford, Forsyth, in the larger two counties, it's hundreds with a reappraisal cycle. And it takes a while to work through that. But Buncombe has really been just a handful of appeals for the last 10 years or more.
Yep. Considering I've handled all of them, but yeah, no, we do not have a plethora, but I would think maybe two a year at most. So
I think we have one or two remaining.
yeah, we still have, we still have a couple still pending, but those are from like one's from 2019. So it takes a while sometimes, and with COVID and right. But that's not really your all's problem when it goes to the PTC.
Once it gets to that point,
They don't send them back down to us.
No. Those appeals to the Property Tax Commission must be filed within 30 days of the notice of the Board of Equalization's decision. And it has to include a copy of the board's decision that kind of proves that they've already been to the Board of Equalization at the county level. These are de novo hearings, so from the new, they'll rule on new evidence. It can be, I guess, the same evidence that they've presented, but they do not take into account prior rulings, basically. If they don't like the Property Tax Commission's decision, then they can go on to the Court of Appeals. And the next slide kind of talks about that. They hear appeals from Property Tax Commission decisions. Again, they have to be filed within 30 days of the decision from the PTC. They may appeal the Court of Appeals decision to the Supreme Court. When it's at the Supreme Court, they'll do a discretionary review of the COA decision. This has to be filed within 15 days of a mandate issued by the Court of Appeals. And if at any point you need me to clarify anything, just let me know and I'll stop. Okay, powers and duties of the board.
I have a question.
Yeah,
Are we able to get a copy of this PowerPoint?
Yeah. I'll send one to Eric. Good deal.
Thank you.
Okay, as Stan touched on earlier, the Board of Equalization can be made up of county commissioners, the Board of County Commissioners, or it can be a special board. North Carolina has about 67 special boards. They are appointed by resolution of the Board of County Commissioners. They must adopt it no later than the first Monday in March, so it would have to be done by then. It's filed with the clerk to the Board of County Commissioners and with the Department of Revenue. And then the Board of County Commissioners normally appoints a chairperson. And I think Kurt touched on this. These are quasi-judicial hearings. Powers and procedures resemble a court of law. It's a fact-finding board. The decisions you make will be based on evidence that's presented by the taxpayer and by the county and existing law that's already within the Machinery Act. Decisions do not set precedent and do not create case law at this level. They should be consistent and uniform. You want to make sure that you are staying consistent across every taxpayer and neighborhood and all of that stuff. The decisions can be challenged. They're not final until 30 days have expired. So 30 days after the decision of the board would be when those are final. And you took your oath of office today, so that's the first step. You support the Constitution and laws of the U.S. and North Carolina. You can't allow your actions as a member of the board to be influenced by personal or political gain. If conflict does exist, say there's a relative, a business partner, corporate, anything like that, it would be recommended that you excuse yourself from the deliberations for that particular case. And clerk to the board. Authority shifts from the assessor to the Board of Equalization when the board convenes, but the assessor is the clerk to the Board of Equalization and Review. But if the assessor is presenting evidence or defending a listing value or anything like that, another employee in the tax office can take on that clerk position. The clerk's responsible for keeping minutes and providing copies of evidence to the board on hearing days. Another duty is to hear taxpayer appeals. You'll hear timely appeals about reductions or increases of value on the taxpayer's own real property or personal property. Basically, you will be determining the appropriate value of a real property as of January 1st of the reappraisal date. So for this year, that would be 2021 would be the reappraisal rate. For personal property, it's valued every year. So it would be January 1st of the tax year. So for this year, January 1st of 2024. You'll also hear about late applications. You may approve acceptance of late applications for exemption or exclusion for the year of 2024. This applies only to tax levied in this calendar year. You can accept applications for prior years, and you may accept for good cause. It's not defined by statute, so it's kind of a discretionary thing. After adjournment, any applications that need to be approved should go to the Board of County Commissioners. Power to submit reports. The Board of Equalization can submit reports to the Department of Revenue. They can outline the quality of the reappraisal, problems in the process, the quantity of appeals that you have coming to the Board of Equalization and the Property Tax Commission, the success rate of those appeals. And then you would report like the name of the company that did the reappraisal, or if it's in-house, you would kind of note that. The DOR obviously encourages all counties to submit this report. Okay, hearing preparation. Preliminary assessor review. The assessor should review all complaints prior to scheduling with the Board of Equalization and Review. That's for 2024. For 2025, they should do it prior to the board convening. Any factual errors will be corrected at that time, so that they don't bring anything that's a factual error. And then maintain standards of equity and fairness. Determining the time of meetings. You may continue to meet after adjournment to decide timely appeals. So that's what you're here for today. That's what you're going to hear. These were appeals filed timely and that they just didn't get to before the board adjourned. It's important to be realistic in determining the time needed to hear all the requests for hearing, and the number of hours and the frequency of meetings. And this provision is what allows you to hear today's cases. Some general recommendations from the DOR: convene as early as possible within statutory time frame. In a reappraisal year, you would allow the board to stay open for 3 to 8 weeks between convening and adjournment. A non-reappraisal year is usually 2 to 6, but with the hurricane and all of the damage and things that'll be coming in with that, it will probably need to be extended for this year. So just keep that in mind. When you're establishing the timeline, keep in mind fairness, uniformity, and adequate time for the commissioners to set the tax rate. This is just talking about the notice of hearings. Newspaper notice advertisement must contain the date, location, hours, the purpose of the meeting, convening and adjournment date and time, and early or late adjournment procedures. When you publish these, it'll need to be in a newspaper of general circulation. The initial publication is 10 days prior to the first meeting. So for 2025, it would be 10 days prior to the first meeting of the board. And you have to publish it 3 times. And format of the meetings, maintain appropriate level of formality. Determine that format at the beginning and kind of keep it uniform, carry it through. You'll adopt policies, and I'm sure Eric will have some recommendations like sign-in sheets, hearing scripts, evidence logs, things that kind of keep everything organized so that it kind of stays uniform across every hearing that you have. Open meetings law, which will probably be something that you can defer to Kurt on. Sunshine laws, hearings, deliberations, and actions are public. So the public should have access to records and it should follow the retention schedule. Any confidential information can be redacted. It needs to remain confidential. So things like income information. Okay, appropriate issues for appeal. Real property appraised substantially above market value as of the most recent reappraisal. So that would be as of January 1st, 2021 for any that you're hearing today before the 2025 session convenes. Legal, it would be discovery for failure to list by the property owner if they didn't list a certain piece of property. Listing versus late listing, so listing after the listing period. Exemptions and present use value. Inappropriate issues for appeal would be tax amount, the amount of the bill, the level of satisfaction with county services, the percentage increase in tax or assessed value, economic decline of the real estate market, and then post reappraisal refinance reflects the lower market value. So basically, if they've had an appraisal after the reappraisal date, that wouldn't be a reason for appeal. Next, we'll talk about the greater weight of evidence test. It would be compelling evidence. This evidence would need to be based on market value, qualified sales, arm's length transactions that don't show any bias or anything like that. You wouldn't consider your personal feelings on the type of property, expert witnesses, political affiliation, financial situation, where their primary residence is, or the taxpayer's physical characteristics. So market value evidence, questions for the taxpayer, the expert that they employ. You would ask if they have an appraisal report for real or business personal property. Is the property or the assessment accurate? There are a couple other things that probably don't need to be considered for this specific hearing that will go in more into the full charge. But another one is the subject property assessed comparably to similar properties. So is it consistent with other similar properties? Recent appraisal performed prior to the reappraisal date. For business personal property, which I think Eric said would be some of the cases that you would be hearing today, that reappraisal date is January 1st of the tax year. So for the ones that you would be hearing today, that would be January 1st of 2024. Appeal decisions. After you've considered all the evidence, the Board of Equalization will adopt an order either reducing, increasing, or affirming the listing or appraised value under appeal. Next, the appellant will be notified of that decision. It has to be sent no later than 30 days after the board adjourns. And it must include instructions on how to appeal to the Property Tax Commission. I think that's normally something that Steve with our office sends out to assessors every year that need to be included with the board's decision so that the taxpayer knows the steps that they need to do to appeal to the Property Tax Commission.
So after they've made their case, we discuss it up here.
Yeah, it's all public. So the taxpayer can be present for your decision. So you would have your deliberations and whatever agreement you come to would be done openly.
But all your deliberations would be done in an open session.
Mhm.
Really, the only time that you could go into a closed session is to ask an attorney, like the board's attorney or your attorney, some legal advice or something that may be applicable to the case that you need to understand. But otherwise, everything would be open. Thanks. Sorry, I didn't mean to.
No, you're great.
That one, in this format, so typically what would take place is the appellate will state, the county may have some general information to introduce to the appellate. coming before you is XYZ. They are appealing their business personal property valuation and where the property is located, just general, generic, nothing that's tainted in one direction or another. And then the chairman would ask the appellant to state their case. What are the concerns and so forth. And you can ask questions of the appellant while they do that. And then if they have rested, they're presented all their evidence, they're comfortable, county has to defend. And the same thing, the county will defend their position. You can ask them questions. It may be that as a result of that, the taxpayer wants to ask a question. Taxpayer or representative should not ask the question directly to the county. The county should not ask a question directly to the taxpayer. They should make their question to the board, and the board then instruct them to respond. You want to keep it as open and congenial as possible, but you really want to restrict the idea of them having a conversation that gets out of hand between the parties. So, and then when that's all concluded, you have any other questions, you're all rested, then you start, as Kurt mentioned, the deliberation process. And generally, depending on the issues, some appeals are very quick, some may take a while. Just depends on the issues and severity of those issues. So,
And if we need to go look at the property, what will we do? Table it and then come back?
you have, and we'll get into that more for your 2025 session charge, but you do have the authority to, one, designate someone from the board to go out and look at property, or you as a whole board to go look at property. It's becoming more and more rare that that is the case because there's so much information available in the county's database, especially about real property. There's all sorts of imagery that we have collected. We fly ortho imagery for the state now once every 4 years, every county. We have LIDAR, which is great for determining how much topography a property has. In fact, we settled a case we had before the commission. Eric helped me with that using LIDAR elevation data to settle a case. I did go out and look at it, but that was just a customary thing to do. It wasn't required. And so some of those things, and I will tell you on business personal, I go to a lot of business personal sites. Sometimes I have to sign a disclosure agreement that I will not disclose anything I see. Fact of the matter is, I don't understand 90% of the technology in these properties that are business personal now. The technology is just so advanced, but so you will decide that, and you can weigh that, and your counsel and your assessor can help provide you some information along those lines. But you're not restricted, you're not forbidden to go out. You can go out and look. Yes, sir.
Can you just give an example of, since none of us have ever heard an appeal before of an appeal that that this board, rejected and it made it to North Carolina. Can you give an example with names, especially for residential property? I mean, how does it even, with all the facts and data that you have, how did it even make it that far?
Quite simply, the property owner or taxpayer is simply not satisfied with the result that they got from the Board of Equalization Review. That's true in every county. We get a lot of residential appeals. Probably still more than we do percentage-wise across the state, taking the state as a whole versus commercials. But the larger counties such as yourself, Buncombe, again, Mecklenburg, Wake, Guilford, Forsyth, Cumberland, they're going to be more probably multifamily appeals, where it's a condo project, it's a apartment complex, it's some sort of multiple family housing, or it'll be just a pure commercial property. It's the McDonald's, it's the any business that it may be, and they appeal simply because they still believe that their value is too high as that decision rendered by the board. And we will give them an opportunity to provide us some information that we can then share perhaps with the county to see if, with the county attorney's counsel, come to a meeting of the minds. Not every appeal that is made to the Property Tax Commission results in a hearing. And I would say probably in Buncombe's case, it's probably, some of the smaller counties where it's mostly residential, we probably have consent orders go out on about 90% of those appeals. So only about 10% get scheduled for a hearing before the commission. The more urban counties, wait, again, we've mentioned those, it's a higher percentage that gets scheduled for a hearing. And we can only schedule so many per month. And so if you look at it, we do have a 19 or 2 case. I have one from a nearby county that's 19 on a commercial appeal. There's only so many you can hear at one time before the commission. So, but they, again, it's as long as that taxpayer feels aggrieved, they have a right and an avenue. And all it costs is that postage stamp and a photocopy and mail. Whatever they send us needs to go to the county attorney, needs to be mailed to the tax assessor or county assessor, so that all the parties involved have a record of what has been appealed. But it can be until it becomes expensive to go to the Court of Appeals. Let me say that. It's much more expensive for an individual property owner to appeal to the Court of Appeals, and to the Supreme Court if they have that avenue. Rarely is it going to be that. It's going to be a commercial appeal, or it's going to be something that's of a legal nature that gets appealed up, not of a valuation issue. The valuation issues at the Court of Appeals are very small. The ones that go up again are because somebody believes there was a misinterpretation of law or misapplication of law, and that goes on up. And then if you read a case from the beginning at a local level, say to the Supreme Court, it changes. There's a lot of factors at the local level, in front of the assessor, in front of the Board of Equalization Review. There's less before the Property Tax Commission, and there's even less detail. There's more argument, less detail about what started the appeal as you go up the chain of appeal. So I don't think I've probably answered your question, but I'd be willing to talk to you more about it after the
Yeah, I
meeting if
mean,
you'd like.
I get where apartments and condo complexes and all those, but I'm just thinking about the guy that lives on 43 State Street, in a house, and he appeals, and then we deny it, and he goes to the next level. I mean, how does that even happen? I just don't.
I mean, I can just say from personal experience, being here for a long time and handling all the appeals, it is very, very rare
Yeah, that's what
that an individual homeowner, because number one, they got to drive to Raleigh for the hearing. But and most of the time we work to resolve those.
Right.
Most of the appeals are either over whether a property should be exempted, like whether they're a charity or something that property should be exempted. There are more novel and unique situations as opposed to just what's the value of the property. Now with commercial properties, there are different appraisal methods, and sometimes they'll argue that we use the wrong appraisal method to value their property. But those are, but the residential stuff is very rare.
Okay, so I'm gonna go off on my last slide. Doesn't really pertain to any of this, but it's just going over what the notice of decision from the Board of Equalization needs to include for the taxpayer. So the date the notice was mailed, the parcel number, a description of the property under appeal. Usually that'll be a parcel number. The value under appeal, the value that was determined by the board, the address and deadline for appeal to the Property Tax Commission, a statement to provide a copy of the notice with the Property Tax Commission appeal. So they need to provide a copy of the notice that the board sends out with their Property Tax Commission appeal. And then the Department of Revenue sends out recommended language for those notices as well. And I think that's the end of my spiel.
Earlier, Lindsay mentioned Steve. Steve is sort of to our agency in Raleigh, the same as Kurt is for the county here. He's our legal counsel and serves as secretary to the commission. Okay.
And here, I'll make it a little bit bigger for you.
Thank you.
So if we do something that the county doesn't agree with, they're saying, hey, y'all shouldn't be doing that. Who do you?
Well, I mean, it's quite possible. Now, once again, I would need to define my role as to whether the county attorney is providing legal. I can't do both. I cannot represent the county and also provide the board specific legal advice. So normally what happens is that we will either be providing the board legal advice, and if somehow the county has an interest that I can't do that, we would provide you with the outside counsel so that there's not the conflict. But yes, there are situations like I would say a tax exemption where, let's say the appraiser feels that this property is not charitable or shouldn't have the property tax exemption, and suppose you all feel that they do. That's quite possible that the county could then appeal that to the property tax commission. Once again, happens very rarely. So it's not, we try not to go to the PTC. That's usually where we're at. And most of the time when the Board of ENR renders a decision, we if it's a, fair and just decision, we go with it. And I can't remember a time where we said, no, that's not, but that's always a possibility.
Okay. These apply, the uniform appraisal standards, they apply to all properties. Real, personal, and all the different varieties of real and personal property. You're to appraise by statute all the property at true value, and I will tell you that there is a statute that will go over a lot more in depth for real property as you start your next big session in 2025, and especially when you start your next session after a reappraisal, to bear in mind. And it's essentially the same standard that all American appraisal societies operate under. And USPAP, if you've ever heard of USPAP, Uniform Appraisal Standards, that one they're all the same. So we are a market value state. There are states that are fractional assessment in that they try to determine a market value, but then they assess at a percentage. South Carolina next door is one of those states. But we are a market value state, and the definition in our statute mirrors that. You're trying to determine as best you can, and the county has already gone through this exercise, as best they can determine what would that property sell for, most likely, given all the different possibilities on January 1 of the reappraisal year. And so you're kind of at an advantage now that you don't have any of those real property appeals, as I understand it from Eric, on your calendar immediately, but you will have some in 2025 as a result of Helene and primarily damage from that has not been rectified or improved upon as of January 1 of this year. And we'll go into this definition in a lot more detail, give you more examples of each of those. This one, thank you. It's good to have someone who understands the technology sitting next to me. Market value, the more important things, and this goes back to people, how they see their property. It's not historical cost, it's not construction cost, it's not, and for the one that's in red there, depreciated asset or book value has to deal with business personal property. That's a lot of times what the basis of their appeal is coming to you. Insurance value, value in use versus value in exchange. Market value is value in exchange. Liquidated or salvage value. You may come across that for 2025 again because of properties that where the equipment was ruined as part of Helene and so forth. Inheritance value and aesthetics, aesthetic value. Those are the things that's not a part of market value. And the big one coming up now, personal property. If you give me an option to go to Charlotte and appraise the largest multi-floor skyscraper of what, 60-something floors in Charlotte versus go in and appraise someone's machinery and equipment in their small business, or I'll go to Charlotte because I can get a lot of data. It's not as easy with this. So we have here, you'll see in red, NCDOR cost index and depreciation schedules. That is the basis for which most of the valuation of business personal property is structured. We ask property owners to tell us the cost by year of acquisition. So over a period of time, they may be adding and deleting equipment on their books. So we end up adjusting that. And then based on some time factors, the depreciation schedules are developed. And that way we apply the same yardstick, the same methodology to every one of these business personal property accounts. That does not mean that the property owner doesn't have an avenue of appeal. He does. He comes to you and he says, well, these were great schedules that the Department of Revenue created and set up, and the county applied them as best they could. But we have some extenuating circumstances we want to bring to your attention. And that's the basis of their appeal. And that's very valid. In some cases, you'll need to know that there's a difference between something such as, say, air conditioning. If air conditioning in a plant is for the comfort of the employees, that becomes a real property asset, the air conditioning. If it's there because it's required as part of that manufacturing process, it's business personal property. So there's some things that you can, with the county's help, their staff, that they can guide you through those little particulars. But those, other than that, that's pretty straightforward. Again, I've been into a lot of plants. I'm amazed at some of the engineering in these plants, but that's not what I'm asked to do. And so I don't always settle those appeals that come to me in that fashion. I can help settle real property appeals confidently and fairly and equitably, but it's more difficult for business personal property.
What's the chance Mission Hospital or the Biltmore Estate, big, giant, I mean, they're probably the two biggest, of them come in here?
Well, they've each been here before. Biltmore came back, what, 20, 30 years ago? And
I haven't remembered Biltmore, but when Mission was acquired by HCA and they lost their real property tax exempt, their charitable exemption, yeah, we went to the property tax commission and I don't think we ever went to the PTC,
No.
but we did have a litigation with them, traded appraisals and things like that. Ultimately, reached I guess a settlement.
a meeting of the minds.
Yes, meeting of the minds.
And was that this board or was that y'all directly, your office?
No, I think you upheld the board. I don't know, sometimes, and the taxpayer will just kind of appeal to this board, but not really present anything, because their main goal is to get to the PTC, so they kind of use this board as kind of a stepping stone, shall we say. And I think that's what Mission did in this case, is they just presented very little evidence. The board didn't find in their favor, and they appealed to the property tax commission. But yeah, that was probably the biggest appeal that we've had.
The last 6 years or so.
Yeah.
His comment about a lot of attorneys who represent, say, the big box stores, the Home Depots, the Lowe's and things like that, they know. They don't really expect you to really give them satisfaction or to explain how the value was reached. They are trying to get, as Kurt said, to the property tax commission, because they are in all likelihood have appealed in almost every county where they have a site. And it's just part of the process. So don't feel obligated to have to justify a no change or whatever on those. Follow the lead of I would suggest you follow the lead from the tax office. And
You would probably know
counsel.
that already, maybe.
I'm sorry?
You would probably know that they're wanting, this is a stepping stone.
Yes, they usually make the attorneys for those type of appeals. It's all, Eric will know that these have been filed in 30 counties or so. It's not uncommon. That'll be shared with you. And yes, the attorneys typically know we got to go through this hoop to get to where we can consolidate all of them.
Correct. And some of these specialized properties we see as appeals will have the county will contract with an independent fee appraiser as well to come and present to the board as well. So
So I have another question about Mission Hospital. If they own 27 properties here, separate properties, places all over the place. My wife works at Mission. Would I recuse myself?
I would probably advise you to consult with your attorney and to see depends on her position, I think, in part.
She's medical, so she's nothing with the business, medical.
Usually we look at, is there some type of personal benefit that you would get from if you ruled in favor or against as your wife, like for boards of commissioners and things like that. Usually it's, do you own like 10% of the company or does your spouse own 10% of the company? Would they be entitled to that? But in some of those cases, if you don't feel comfortable, just mention it and then the board can excuse you from hearing that matter. Just make sure that we have 3 of you present that we have a quorum before you excuse yourself. Thank you.
Okay. The statutes are pretty clear on all the things that can be considered for real property as well as personal property. And you'll get a copy as you asked. There will be a copy made available to you. We'll go on from there. On your business personal property appeals, especially because they usually have some reliance in the paperwork, perhaps of a Schedule D for income tax purposes. It's really, really important to maintain confidentiality of that federal tax information or state tax information. All of us at the Department of Revenue take courses and quizzes to certify that we are especially diligent, vigilant about observing federal tax information and not allowing it to go out. A lot of times it's redacted in terms of some documentation, but they still might be testimony about it. Just be very, very careful of handling anything like that in terms of it showing up on a screen and somebody taking a photo of it or something. That's the main thing right now for your consideration on that. The same rules apply here, the same recommendations here, looking at just some really common sense about business personal property. What's the replacement cost of the property? Has there been any sale prices of similar property? And that's a danger because when it usually sells, it's for salvage most often. Sometimes it gets sold. It gets pulled out of Old Fort, North Carolina at a textile processing plant and sent to Venezuela. But that's, again, not a good example. It's hard to find really good sales of comparable property in terms of that scale. A little bit easier if it's a Hardee's equipment selling to some other fast food, maybe not big name, but be careful about that information. Remaining economic life, the productivity of that property, all those are things that they bring in. I did have an appeal from the paper mill in Canton that just recently sold. This is going back into the 90s. They brought forth a very interesting piece of evidence. They could show that the demand for their paper, and they were obviously bought a lot of bulk mail. When that changed at the Postal Service, it was like a shadow effect. When the bulk mail demand went away, so did that demand for that paper go away. And it was almost a shadow. So you can see some interesting things that come up that you can consider. Giving weight to that and trying to evaluate the weight to a value can be very difficult. And in some cases, the county may have a different argument that you would want to give the exact same weight to than that one. This is what I want to spend a little bit of time on, discovery. This is purely when the county discovers a property owner or a property, it's because the taxpayer failed to do something. He failed to either list the property to begin with, he failed to list a change in that property that occurred in the previous calendar year, but it's always about a failure. It's because maybe they had argued that they should be exempt and it was actually granted, and they never came forward and fessed up that it really shouldn't have been exempt. Those are things that can be discoverable. And when they discover these, when the county makes that discovery, there's a slide coming up here. Is it the next one? No. Let's go ahead and go to that one. No, there we go. Spend some time on this one. This one it's a 10% penalty for the current and 5 previous years. And it's cumulative. Works out to about 210% penalty. So it is not meant to be a little slap on the wrist. It's meant to be, you shouldn't ought to do that. Like my 5th grade teacher did with me on my hand with a ruler. I shouldn't do that. It really is meant to be punitive. Now, it may be that the omission was just for 3 years. You'd go back for the current 3. Wherever that break occurred is what you go back. But your county can only reach back 5 years, current and 5. That's where the 6 years comes in. And I give this to you. It'll be, again, if you have a discovery appeal, I know there's going to be a worksheet for every discovery appeal that comes to you that breaks out what that value is, the amount of value that's being discovered. If the taxpayer never listed, then it's that total value. If the taxpayer had listed before, but didn't list the change, the improvement, then it's that difference. But there's going to be a 10, 20, 30, 40, 50, 60% penalties being applied. And it's meant to be that. Again, go back to the second slide I think we had about 105-348. People are given presumptive notice by law that they are responsible for listing and seeing to it that their property is listed accurately. And if it's not, be prepared for the consequences. So that's where the discovery comes in. The discoveries are usually, and Eric can correct me on this, he knows what the appeals are that he has. They're not gray areas. They're black and white areas. Taxpayer failed to do something. It's not that the taxpayer meant to, but he didn't, then he didn't do it. It's a very black and white process. And counties, as a rule, are hesitant to want to do the discovery unless they've got the facts to back them up. Okay? They don't do it just willy-nilly. Well, I don't like that guy. No, that's not why they do it. Because they know it'll come back and bite them. They only do it when the facts say the taxpayer failed to do what they were required to do. The other things we've talked about this afternoon have been really subjective. In a lot of cases, your appeals that you're going to be hearing are subjective. How does the appellant determine their opinion of value? How did the county determine their opinion of value? And there can be subjective differences. And that's where, in most cases, as Kurt mentioned, if it goes to the state and we have that situation, we try to reach a meeting of the minds. But in a case of a discovery, it's pretty black and white. And you do have some of those. How do I go back? That's good. That's good. So those examples again, property was listed, not listed, was listed after the listing period. They can actually list it, but it comes to you on February the 10th. And it was postmarked after January 31st. That's a listing discovery for that 1 year. So that can happen. They listed an understated value. That happens sometimes. Property listed under an exemption. We've had some court cases on that. In fact, one case out of Macon County actually changed how the discoveries were defined. And this one, we've talked a little bit about the taxation and penalties. Did that. The power to compromise. Once a bill has been, the tax has been billed and it's remained unpaid, property owner can go and petition. In your case, I think your Board of Commissioners has delegated that authority to compromise to the Board of E&R. Is that right, Eric? Has the Board of Commissioners delegated the power to compromise to this board? Then you will hear, so you've already ruled on the case. It's gone through and a tax bill's been generated. It's remained unpaid and the taxpayer comes forward and wants to have a compromise. And the statute provides for that. I will caution you that there is no standards in what you consider on the basis of a compromise request. There's no threshold, minimum requirement to have them come forward. There's no ceiling. It's, as one of the law professors in UNC said one time, it's like letting a bull roam in an unfenced pasture. And because there's just no standards. And there's strong emphasis from some avenues that it's probably an unconstitutional statute, because so often when the tax is compromised for, again, no basis of fact, versus when it's not on the same kind of evidence or same kind of presentation, you've actually treated two property owners, two taxpayers with the same basic argument, totally different. And that's what we try to get away from. If you read some of the amendments, equal protection under the law, we should have the same, as Lindsay pointed out, treat everyone essentially the same. So if you have that, I would definitely recommend you sit down and have a conversation with county counsel there. And when I say counsel, I'm talking about counsel is from the attorney, and proceed cautiously. As you can see, it would be nice if we had some written guidelines for that. We don't. If you can come up with some good ones, we'd like you to share them with us, and we'd like to share them with other counties. Any other questions for Lindsay or myself? If not, thank you for not throwing anything at us.
Thank you.
Thank you.
You have our contact information. Eric knows how to get in touch with us. Lindsay works out of Burnsville. I work out of Hendersonville. And Lindsay she's the bright face for the Department of Revenue. I'm the old grungy face. I've been at this for about 40 years. And so she's the bright new face. So feel free to contact either of us if we can be of any service. Thank you.
Thank you.
Yeah. How often do y'all come to these? Or you just watch it over the?
This is my first one.
Oh,
I'm into the hundreds.
but you actually come to our meeting.
No, if Eric or Kurt would ask, we would certainly sit in, but we would not testify, and we would not offer any conversation or directions for the proceedings. We would simply observe.
Thank you.
Sybil Tate, our Assistant County Manager, is going to drop in and say a few words. Yeah.
Yeah, I just wanted to say hello and thank you for being here. Thank you for your service. Again, as Eric said, I'm one of the assistant county managers and I work with the tax assessment department. I'm here to support Eric and by extension you all. So if there's anything that you ever need from the county manager's office or from the Board of Commissioners, please feel free to reach out. So thank you and welcome to the Board of E&R.
Thank you.
All right. Next item on the agenda is the new business section. They're both items there decided on the first hearing for May 2024 appeals. And item B is decided on the adjourn and convene dates. I want to throw out there one option is something we did earlier to set this date, which I think Phil actually suggested was an email poll. That is an option if you don't want to align on a date today. So you all can decide on that. Fourth motion or whatever you choose to do.
We'd have to get our calendars and stuff like that, and make a decision then.
Yeah,
Probably. Right, so the email.
Yeah, Eric, I think the email is
Email's
the
better.
simplest way for everybody to see everybody else's and try to align in the best way possible, so it's as convenient for everybody's schedule
Yeah.
as possible. So if we can do that, that would be great.
Yeah, certainly. I can, I'll send out an email, or me or Ann will, with the first hearing date for the upcoming, to hear these 2024 appeals, and then I'll send a separate poll for the convene and adjournment dates. So we can get those out there, and then we'll get everything properly noticed and so on and so forth.
And I just want to make sure that everybody's aware that any emails that we sent, that it's more for just a poll. We will have to take formal action at the next board meeting to adopt those dates. But just be careful. All the emails, welcome now that you are publicly appointed, that your emails regarding the Property Tax Commission are public records. So just make sure that you're aware of that. And I guess my rule of thumb is don't put anything in the email that you wouldn't want printed in the Citizen Times. So keep that one in the back of your head, okay?
Yeah. How much can we talk to each other outside? Can it just be one-on-one?
Well, that gets into the open meetings question. Okay, so if a quorum of you, which would be 3, more or less get together and have the ability to deliberate or discuss an issue, that would be frowned upon, and that really should be an open meeting. But if like one of you runs into another at the grocery store or something like that, that's not a violation of the open meetings. But like if a group get together like that, it would be. And that's kind of why the emails and doing things online can get to be a little hazy. And that's why I wanted to make sure that you all understood that we wouldn't be taking any formal action, so that we do that. But most of your deliberations, and you really should not have a whole lot of issues outside of people's appeals. So you really, and the rule of thumb is that you really should not be engaging in ex parte communications about any appeal that is before you. So does that answer your question? Okay.
Yeah. I kind of knew the answer, but I wanted to say it.
Of course.
Any other questions before we move on to the final item? All right. So the final item is discussion of late exemption applications. These are the
All of these.
yes, sir.
names.
Yes, sir. All those. Yeah, those
Yeah.
are
It was interesting
applications
driving
deemed to
by all
be-
these properties.
yeah, those are all applications deemed to be good cause, late applications, as it should say.
So one person I actually know in this whole list. I mean,
Does the fact that you know them in any way going to affect your decision as to that? Okay,
it's just a lady on my street,
sure,
and I've taken care of her a few times, mowed her lawn.
sure. Well, once again, as long as it doesn't affect your ability to be impartial and only consider the facts presented, although we're not at that stage, I think right now the only thing that you need to consider is whether there is good cause to grant the late appeals. And I think we're going to do this as one big mass.
That's what I figured. Yeah.
And so I think it, due to the hurricane and other factors, I think that staff would recommend that we grant the everybody's late appeal
May I ask what the cutoff
application for late appeal.
date? What was the actual cutoff date for submission?
June 1st.
That's what I thought. Okay, I just
Yeah.
wanted to confirm.
I knew that it was way before the hurricane.
Sorry, Whitney Agricultural Supervisor is actually here in case we have detailed questions. She's trying to tell us something additional.
So
With the elderly exemption, the disabled veteran, and the disabled exemption, those application dates had to be in our office by June 1st. However, any exempt properties, which is the 501c3s, the churches, present use value, had to be in our office by January 31st.
Of 2024.
Correct.
And so when these are submitted, is part of the requirement an explanation of why they missed the deadline and then they come before, I mean,
Yeah, so let me give you an example, like the PUV that's on there on the document this time. So what happened is the property split, and when the property split, it automatically went out of the present use value area and went into a regular real estate area, and we did not catch that until the taxpayer got it. The churches, there was a plat that was recorded on several of the churches. They never split. There's just the plat was recorded, and it split based off the plat.
Split without a documented title being a deed of
Right.
transfer, things like that. So they would need to reapply with that new parcel ID. So every time a parcel splits or gets combined together, they get a new parcel ID, which is essentially like a social security number for a parcel of land. If it changes anyway, the parcel ID changes. So that's what would have happened on those typically exempt parcels, like a church,
Yes.
if they record a subdivision plat.
so my only other question about this list is how late were they?
They vary.
But definitely after June 1st.
Yes. Yes. And I can tell you that we have looked over all income. We have looked over the properties. We've looked over the documents, like the disabled veterans have to be certified. The disability statements have to be certified by a doctor. We've looked over why they said they didn't get their application in on time. And we believe by general statutes, what we have to go by, that's
meet
why
those
they meet those requirements, and that's why we brought them to you today.
Okay. That was my question, is how do you verify the process of making sure that not only that their eligibility requirement is met, but that maybe they were waiting on the doctor to certify.
And a lot of times that does
disability.
happen.
So,
A lot of times they can't get in with the doctor, especially with the VA. A lot of times it takes them a while to get certified through the VA. So that does play in a part with that too.
Is this a typical amount that we're looking
Yes.
at here?
Yes.
You even determine that they're eligible even if someone else is on the deed with them?
Yes. So we look at the deed and we see what percentage of ownership that they have. And then based on general statutes and what we have to go by, we give that exemption based on the percentage of ownership.
But your vote today is basically would be allowing staff so that they could consider these late applications as opposed to granting or not. So, but they missed the deadline. And so as opposed to going through each individual one and determining whether good cause exists, we're trying to simplify that procedure a little bit.
Correct.
So do we make a motion?
Yes. So
You make the motion? We make
one of you can normally it would be you. I'm normally a lot more quiet at these meetings, so I'm trying to help. So, but yeah, normally someone would make the motion to, accept, make a recommendation to grant the late appeals and then have a second.
All right.
I'll make the motion that we go ahead and accept the late exemption applications as submitted, so that the staff are able to move forward with the process.
Do you want to hear a second?
A second,
Who, which one got it in?
Preston.
Y'all decide.
No, thank you all. That's
Okay, and then you need to vote.
You need to vote. All right. All those in favor?
Aye.
Any opposed? Everyone said aye, so I don't need
Okay.
to ask that.
That is it.
Yeah, I think we're good.
Is there anything else?
There's nothing else. That's the last item on the agenda.
So,
And I'll email you all a poll and we'll get the next meeting set up.
so usually when you want to end the meeting, somebody needs to make a motion to adjourn and then second and vote on that motion.
I'll make the motion, we adjourn. All those in favor?
Aye.
Aye.
Do you have somebody like keeping track of who's making the motion and who's seconding for the bill?